So what are some divergent approaches that different jurisdictions are taking to regulate AI? Regulators are facing a big challenge: how to protect the public from unintended consequences of AI like bias, job displacement, or security risks, while also encouraging positive innovation and maintaining global competitiveness. It's a delicate balancing act, and each country is finding a different way to achieve it. In the United States, the federal government has mostly taken a light touch approach to regulating AI. The focus has been on issuing guidelines and encouraging innovation rather than putting down strict regulations. However, this approach could be shifting as concerns about AI risks grow. On the other hand, states like Colorado have been more proactive, creating frameworks such as the Colorado AI Act, which introduces specific requirements for transparency, accountability, and responsible AI use. So across the Atlantic, the European Union has taken a very different approach. The EU AI Act is comprehensive and prescriptive, focusing heavily on risk management and ethical principles. The EU wants to ensure that AI systems, especially those that are high risk, like in healthcare or law enforcement, are safe, transparent, and accountable. It categorizes AI applications based on their risk level, requiring stricter oversight for high-risk systems. This risk-based approach means that the higher the risk associated with an AI application, the more stringent the regulations will be. It's a framework designed to ensure that the AI development aligns with the values of fairness, accountability, and transparency. Now let's look at the United Kingdom, which has taken yet another route. The UK's approach to AI regulation is described as pro-innovation and context-specific. So unlike the European Union, the United Kingdom does not propose an overarching definition of AI or AI system. Instead of introducing new legislation that could place, quote, undue burdens on businesses, the UK aims to empower existing regulators to oversee AI within their sectors. The UK's strategy is to keep the rules flexible, allowing individual regulators, like those in finance, healthcare, or transportation, to develop tailored guidance. This approach seeks to encourage innovation while still protecting public safety and ethical standards. It's also important to understand that these regulatory approaches are deeply connected with data privacy laws. In the EU, the General Data Protection Regulation plays a significant role in governing how AI systems handle personal data, while in the United States, state-level privacy laws, like the California's California Consumer Privacy Act, are influencing AI regulations as well. So what's the takeaway for legal professionals? AI regulation is evolving rapidly and differs significantly across jurisdictions. The US seems to be moving from a light touch approach towards more specific state regulations like in Colorado and California. The European Union is focused on broad, risk-based regulation, and the UK is opting for a flexible, context-specific approach that avoids new burdens on businesses. Each approach has its strengths and weaknesses, and staying informed will be key to advising clients effectively. As AI becomes a larger part of our lives, understanding these regulatory approaches is crucial, especially if you're advising on compliance, liability, or technology adoption. Thanks for tuning in, and don't forget to like and subscribe for more insights on how technology is reshaping the legal landscape.